And continuing our afternoon docket, we have a sentencing next, and People v. Joseph Fawley. So there's two pre-sentences report, one for the 25 cases and one for the 26 case. I also had a chance to review letters of support for Mr. Fawley, Mr. and Miss Rue, and from Ms. Coffin or Officer Coffin.
From a judge in Texas as well.
No, I didn't have that.
Yeah.
All right. I don't know what to say about that. I mean, Texas must have different rules than Michigan, because if I were to write a letter like this, I'd be in a boatload of trouble. Judges are not allowed to use their position to ask for leniency for people in other courts' cases. But I'm going to presume that that rule does not apply in Texas, and receive this as I have from any of the other letters. All right, Mr. Gilbert, anything you want to say on your client's behalf?
I'd just like to point out a few things. I know as I went through this file, I was not the attorney on the original cases. Initially, there wasn't even a recommendation for me to have jail. What has caused my client to be standing in front of you in orange was his bad decision making at the time that he didn't show up for sentencing. Because if he would have, the penalty would have been fairly minimal if followed the recommendation. There is some positive things to point out to the court that when he did take off this last time, he just completed rehab. And I guess the concern was that he had to go back to the jail, and at the same token, between those dates, he wasn't out committing criminal activity. And so I'd ask the court to take that into consideration. I would ask if the court could possibly look at, he served, I believe, 102 days as of today, time served, and then a sentence to the rehab, because he does have a bed if the court were to allow him to do that.
All right, Mr. Fawley, you don't have to make a statement today, but you're entitled to. Is there anything you want to tell me or no?
No, Your Honor.
Okay, thank you. Ms. Goodrich, any recommendations?
Yes, thank you, Your Honor. The defendant is 40 years old. He's unemployed with a high school diploma. On September 18th of 2024, the defendant was found to be in possession of methamphetamine at a traffic stop while operating while intoxicated, and the weapon was found in the vehicle. During that case on October 11th of 2024, the defendant failed to appear for a bond violation hearing, so a bench warrant was issued on October 14th of 2024. The defendant was arrested on February 14th of 2025 and indicated in his jail calls that he intended to leave for Florida, but stayed too long and was caught. Absconding was charged. The defendant entered a plea on May 13th of 2025, and a furlough was granted for inpatient treatment, but he was supposed to return to jail after and did not. Sentencing was also set for August 12th at the time of the plea. He failed to show for sentencing too. A second absconding was charged. The defendant at that time had 0 felonies and 1 misdemeanor. His guidelines, as discussed today, are 0 to 17. Based on his bond violation, his absconding twice during this case and incurring those 2 new cases, I would ask for high end of the guidelines and request no probation. I would also ask the court to enter a judgment for gun forfeiture. Guidelines on this case are 0 to 9. This was his first absconding, but then he absconded after his plea to absconding. I think this is the first time I've had a double absconding with a defendant. I again would ask for top end of the guidelines based on the defendant's decisions and actions during this case. Absconding, the defendant felt confident being out of state and had sent emails to the court administrator dictating his terms to return, sent derogatory emails to law enforcement about his escape from the cases. I believe this should be taken into consideration, as well as just to show his mindset while absconding. It's not a mistake or inability to return or having any remorse, but his desire to return was only on his terms and conditions, and then was not worried about being found. When the defendant was extradited back from Texas on February 20th of 2026, he was found across the country within 6 months from his failure to appear at sentence. I give law enforcement credit on their work in finding him so quickly. But even after his extradition, he personally wrote me letters, continued to try to dictate how the cases would go. The guidelines on this case are 10 to 23. The PSI recommendation is for 12 months with 102 days served. I recognize that Mr. Fawley has no prior criminal involvement, but he did abscond for the second time. He was not found down the street or across the state. He absconded across the country, so it should not be low end of guideline. I believe that deterrence and punishment is critical here, since rehabilitation does not seem possible through the defendant's own decisions and actions taken in these cases. And I'd also ask for an order of restitution as part of the plea agreement. It was $3,458.08 for the extradition. Thank you.
Thank you. You certainly haven't made things very easy on yourself here. This case started out in not a great place, not great decisions. We got somebody driving drunk with a gun and methamphetamine. That's a bad start. Those things don't mix very well. And you look unhappy about me saying that, but you're convicted of those crimes.
I was under these, I wasn't drunk.
Oh, it was drugs. Okay, so you were high.
Yes.
And you're laughing.
No, I'm not laughing. No.
You're convicted of operating while intoxicated. So if it wasn't alcohol, it was drugs then. But you clearly don't think you were high today, as your demeanor and sighing and laughing and whatever. But you were. You already pled guilty to that. So you're driving high with methamphetamine and a gun. Does that seem like a good idea to you? It does not seem like a good idea to me. And I don't even know that you're persuaded as you stand here. And then while that case is pending, I mean, that's a bad decision and a bad start. But you know, we see a lot worse. We see a lot worse in this court. And those are all problems that we could manage. That's why you get sent to rehab. And then you don't show back up. So you get an absconding charge. Even after that, even after you fled one time, we still thought, hey, these are problems we can help Mr. Fawley with. You enter a plea to the possession of methamphetamine, the high driving, the improper firearm, and the attempted absconding. And you know, if you just showed up for sentencing that day, you know what the recommendation was? 18 months probation, no jail. I wasn't sure I was going to follow it. My notes to myself show, you know, maybe a little more jail. I don't know, but I was open-minded to it because, you know, we start from a place in this courtroom of trying to help people make better decisions. If it's responsible to do so and safe for the public, we want to try to help. We want to try to give people second chances, third chances, heck, sometimes 10th chances, it feels like. You know, we want to try to do that. We can only do that when it's safe and appropriate. And obviously we can also only do that when the defendant themselves is participating in that process. And you decided you didn't want to participate in that process. So you didn't show up for sentencing and you flee to another state. And they got to go get you. So I'm real glad that you made friends with judges and cops out in Texas. But, you know, that doesn't make things much better for you here. And I mean, it's so apparent to me on this record, based upon your body language and demeanor, that you completely disagree with all the stuff I'm saying here today, which is kind of surprising to me. Like, it doesn't feel like anything I'm saying should be unreasonable to a human who has half a brain. You don't get to drive high with meth and drugs in a car, and you don't get to skip court, and then you don't get to abscond on top of absconding. The prosecutor's right. I don't recall seeing that. Abscond on top of absconding. Taking all those things into account, Mr. Fawley, in 7018, there's $168 in state cost, $130 in the crime victims assessment, $350 in court costs, $60 in DNA testing fee, and you have to comply with DNA testing. And the judgment of sentence will indicate that any weapons that were seized to be forfeited to the agency that seized them. On the improper firearm, it'll be 90 days jail, credit for 90 days served. The operating while intoxicated, 93 days jail, credit for 93 days served. And the possession of methamphetamine, 202 days jail, credit for 202 days served. And that is within the advisory guidelines, the attempted absconding, the high court misdemeanor, with the guidelines of 0 to 9. There's $68 in state cost, $130 in the crime victims assessment. And I'm going to order that you serve 185 days jail with credit for 185 days previously served. Bond violation in both those files will enter the judgment of contempt and order that you serve 93 days for contempt with credit for 93 days served. So in all those files, that's time served. And that brings us then to 7156, the absconding on top of absconding. That is advisory guidelines of 10 to 23 months. Given that this was an absconding case, I think that under those circumstances, it is an appropriate exercise of the court's discretion to order consecutive sentencing. So as far as that, so that means that you're sitting on 0 days credit in 7156 because it's consecutive. I'm sorry, there's restitution of $3,458.08. And when we look at what's the appropriate and proportionate amount of incarceration, the aggravating factors I've hit on here of the absconding on top of absconding and all of that. There are also mitigating factors that your lawyers pointed out that you weren't, as far as we know, you don't have any cases pending out of Texas from criminal activity out there. Surrounding yourself with some better people. So that's all mitigating factors as well. So I don't know that a top of the guideline sentence is appropriate. So in that case, Mr. Foley, I agree with the prosecutor, prison is appropriate. So I am going to commit you to the Michigan Department of Corrections. It'll be for a term of not less than 16 months, nor more than 4 years. That's just shy of the midpoint at 16 and a half months. And I think midpoint sentence consecutive sounds about right on these facts. So, Mr. Foley, that's the sentence of the court. You may obviously file an appeal if you wish by filing an application.
Judge sentenced Joseph Flea to a term of 16 months to 4 years in the Michigan Department of Corrections, consecutive to his other sentences. That means he'll serve time on top of the time he's already done. The case started with a traffic stop where the defendant was found driving high on methamphetamine with a gun. He was given opportunities, rehab, probation, second chances, but he failed to appear for sentencing twice. He fled to Texas. He sent emails to the court administrator dictating the terms of his return and derogatory emails to law enforcement. The prosecutor called it absconding on top of absconding. The judge noted the defendant's body language and demeanor, saying it appeared he disagreed with everything being said. The judge also revealed that if the defendant had simply shown up for sentencing, the recommendation was 18 months of probation, no jail. Instead, he's going to prison. The broader implication here is crucial. Choices have consequences. Fleeing from court doesn't make your case go away. It makes it worse. Sending arrogant emails to court staff doesn't help your cause. It demonstrates a lack of remorse. And when a judge offers you a chance at rehabilitation and you reject it by running, don't expect leniency when you're caught. If you found this case as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next session.